really excited to be here as part of the Portland Film Festival. My documentary, The 90s Club, is playing in the festival, and I'm very happy and excited about that. For the past 30 years, I've really been more of an entertainment lawyer, and I've worked on tons of movies, but this was the first time that I actually had to the opportunity to produce and direct a film. I've worked, and my colleagues, Jeff Watkins and Romello Hanian are on the line as well. And through the years, we've worked on several hundred motion pictures. Some of my personal favorites have been Eternal Sunshine of the Spotless Mind and Brokeback Mountain. Really complicated, fun one years ago with Lord of War. During this past year, had two films I worked on that were at the Cannes Film Festival that won awards. One of them is playing on Amazon now, which is the movie Annette with Marion Cotillard and Adam Driver. The other one took the grand prize, which was A Hero by the Iranian director Asghar Farhadi. And one of the I don't know if it's ironic or just kind of interesting things is that more often than not, the legal fees on many of these movies that I've worked on is actually higher than the production budget for my own documentary. So what we're going to do during this session is to give an overview of all of the different kinds of legal contracts that you can encounter in producing a motion picture. And many of these apply, whether you're producing a small independent production with very little budget, or a theatrical motion picture with a $200 million budget. And so we're gonna walk you through that. And the legal work on these pictures often begins way before the start of principal photography of the picture, and oftentimes ends even after the completion of production of the picture. We're going to spend some time on what is probably the most important and significant element of the legal work on a movie, which is chain of title. And what that means is the proving kind of the ownership of the movie. Romello, I'm going to turn it over to you for the moment to talk a little bit about some of the various types of underlying rights for a movie, whether it's a documentary film or a scripted motion picture, and the type of rights agreements that you'll need for those.
Sure. So one of the most common ones is a literary rights agreement. That is usually when there is an underlying book or a play, and you're using the agreement to acquire, movie rights to be able to use those literary materials. It's a super common one. A lot of movies are based on books, and we see those very often. You could also, though, just have a general rights agreement where you are being assigned the rights to, anything, a screenplay. You could have a screenplay rights agreement where it is specifically a screenplay that you're getting the rights to and being assigned those rights. And the key thing for any of these agreements is making sure that the agreement covers what you need. So if you're doing a movie, you want to make sure you're getting the rights, of course, of the film, but also to exploit the film. Where do you want to exploit it? What specific rights do you want along with those film rights? Any ancillary rights, any side rights. And you want to make sure that the parties are on the same page as to what's being granted to you. Sometimes, especially when it comes to screenplays, we'll have someone come to us after the screenplay has been written. Maybe they're already in the process of selling it. And somebody might mention, oh, somebody helped me with a certain part of the screenplay, and we had a falling out and they're not involved anymore. And that, we have that raises a red flag to us, because if somebody is contributing to the rights, especially the underlying rights, we need to make sure that everybody is on the same page. The chain of title is clear. Just because somebody, you know, you had a falling out with somebody and they're no longer involved doesn't mean you can kind of just cut them out of that chain of title process. Everything really needs to be buttoned up.
Ramel, I'm going to jump in here because I think you raised a great point. On independent productions that we've worked on, one of the most common issues that you hear about is, or there's no paperwork between best friends.
Yes.
Who even relatives who are working together on a production. And then, you know, when it comes time to put pen to paper and say, we're really agreeing and this is 50-50, suddenly somebody wants the split to be 60-40, or there's 3 people that were working together and they always thought it was going to be a third, a third, a third. But no, suddenly one person thought they were getting 50% of whatever the eventual pot would be, and the other 2 think, or they thought the other 2 would get 25%. So some of the biggest fights that we've seen in documenting the rights to a motion picture are amongst friends, or former friends.
Yeah, and I'll jump in there too. It's not even limited to money either. Like, I've seen, you know, friends or colleagues that have been working together for years. It's not even necessarily the one thinks that they can take advantage of the situation because there's no paperwork. It's just that they had completely different ideas about how this was going to go, about, you know, like approval rights over the final cut, or how it's going to be distributed, and how it's actually, like, how the film's actually going to be exploited. Whereas, you know, both thought that they, you know, that they were like co-producers, or one person might think that, no, I'm running this thing. So yeah, it's just trying to help that, like, it's good to have it documented to know how the relationship's going to go in the future.
Yeah, and I think it's a lot easier. It's a lot clearer to have that discussion before things start moving, because later, as the project maybe gets more valuable, it's maybe more likely for a dispute. It's always good to have a really clear understanding in the beginning before you're actually beginning to work together, I think.
And so, yeah, again, you highlight one of the reasons why this is incredibly important, and that is chain of title is often a condition in 2 instances. One, for your financing, because whoever is unless you're self-financing your own production, where you could defer a discussion about the chain of title, whoever's writing the check, often they or their lawyer is going to want to make sure that all of the rights to the movie are buttoned up in every which way. The other time that you need perfect chain of title, even more perfect than the financing often, is at the point where you go to distribute the motion picture. Because whether you're selling to an Amazon, a Netflix, or Universal, or Paramount, Sony, every single distribution agreement, the very first clause you see is all of the studio or licensee's obligations, including their obligation to pay you that big check, are conditioned upon approval of that chain of title.
Exactly. Yeah, really, it's like Bob said, it's not the first question. It's one of the very, very first thing that comes up anytime you're approaching them. I want to highlight one thing, because we are talking about acquiring the rights, to make a film based on a book. Publishers, especially recently, I just want to highlight that because, in the past, whenever you're getting the rights to a book, there's a publisher's release, right? And that's basically the publisher saying, I have rights to this book, but I only have publication rights. I have the right to publish the book, but I'm, confirming and affirming that I don't have television or movie rights to that. Over the years, they've actually become more of a negotiating point as things like podcasts or other groups of rights become, more kind of to the forefront. And recently, I actually had, I was dealing with a book, rights to a book to make a movie, and we asked to see the publishing agreement and to do a release, and thankfully we did, because it turns out the publisher actually had rights to make a movie. It was kind of snuck into the agreement, whether intentionally or as an accident, and it turns out the publisher actually also had the rights to make a movie. That's not something that you want to stumble upon, because of course you're the ones getting rights to do the movie, and your rights should be exclusive to do so, because obviously you don't want to be paying a bunch of money and now you have, you know, competitive projects being made. So want to touch on publishers because they are important when you're acquiring the rights to a book, and they might, you know, intentionally or accidentally have rights to something that you're trying to get. So always good to get a publisher's release or a quick claim, something coming from them saying they don't have television or movie rights to what you're trying to get to.
And you know, a lot of times these projects begin with option agreements. A lot of filmmakers are familiar with that term, and you can sometimes, especially in the independent world, option the rights to a book or a screenplay almost for free, right? And you know, as long as there's a promise by the producer or the director to at least like put in sweat equity and to try to make something happen with the project, that's probably enough of what's called consideration or of an exchange to validate the contract. But if there's payment of some type, and again, I've seen payments as low as $1 be in a contract. Rest assured, though, at some point along the way, even if it's at the distribution stage, somebody's going to ask you for proof that that $1, that $100 has been paid. So it's really important that you keep records, and then if you say you're going to pay somebody $1, $100, $1,000, $10,000, that you have copies and proof that all those payments have been made along the way. And the chain of title that we're talking about needs to be an exact transfer. So if Ramella wrote a screenplay that I optioned personally as Bob Darwell, and we have a contract, great. I need to show that contract. I need to show the payment that I made to Ramella. But oftentimes what happens almost in every instance, and we'll talk about it in a few minutes, when you do go to make a movie, I wouldn't do it in my own name because I want to, you know, have some protection around myself. I'm going to form some sort of single purpose production company, Ramella's Movie Productions LLC to make that movie. And then I need to actually have a transfer document. When we talk about assignment, we mean transfer. There actually needs to be at least a piece of paper that says that I now transferred it to that single purpose production company, Ramella's Movie LLC. Every single step of that chain of title needs to be documented eventually in order to prove that you have the rights to make the movie. I think on a lot of, and we're going to focus a bit more on independent productions than mixed studio productions for purposes of this presentation. I think a lot of independent movies tend to be, whether it's a documentary in particular, of course, but other movies that we see are based on someone's life story. And I'm going to have Jeff talk a little bit about what it means to produce a movie based on, a real life story.
Yeah, so if you're basing a movie on a real life story, it is best to have the rights to that story to make sure that there can't be a suit brought against you by the person that you're basing the movie on. The agreements look very similar to a rights option that Ramella was talking about. You have an option payment that you put forth in order to buy a certain amount of time to set up the movie. If you end up moving forward with the movie, that you have a purchase price that you're going to be paying. The big key on life story rights, so that's different from a book option, is really trying to define what life story rights there is. As the producer, you're going to want to define that like as broadly as possible. You want their whole life, potentially. You want to be able to have the story start from birth and go all the way through present day, and you can tell anything you want. the person that you're purchasing the life story rights is going to want to define that more narrowly, because maybe there's multiple fascinating stories about them, and they could potentially make multiple movies about themselves. So that'll probably be the biggest piece of negotiation between the two of you, is trying to really define what those rights are. I would say at a bare minimum, you're going to want to figure out, okay, like even if you haven't written the story yet, really what is the story you're trying to tell, and make sure it's broad enough that the rights that you're getting absolutely cover everything you want to tell. Apart from that, if you get more rights than that, that's great, because then maybe you can make another movie about that same person later. But make sure you get absolute minimum rights that you want to tell in that one. Aside from that, though,
No, go ahead.
I think we were both trying to jump in, Jeff.
Right, go ahead.
Okay, I'm gonna say really quickly. I'm just gonna say that's super accurate. And I was gonna say one thing that came up recently is we were doing a life story rights deal, and it was really important. They were fine with us having a broad, grant of rights to their life story, but it was really important to them. They had specific carve outs that they did not want us to portray them in a certain way. Like he was in a long-term marriage. He said, you cannot have me, in the movie cheating on my wife. That cannot be a storyline. Or you cannot show me being drunk or, high on drugs. He was good on the life, like general grant, but he had specific carve outs where he was like, I don't want to be portrayed this way. And otherwise, you can have the rights for, per our deal. So sometimes there doesn't come up.
Yeah.
So, so, I mean, this is one of the problem areas or that we see with a lot of producers when they're starting out. They feel very fortunate to have obtained the life story rights to someone famous. And what they will do is promise that person or their family a lot of control in connection with the production, or even approval type of rights. Right? Approval over who's portraying them in the movie, approval over the screenplay, approval over the cut and the casting and all of that. And most financiers will never accept any of that. So you have to be very careful in doing life story rights to not accord the person that is granting you the life story those type of rights. You would never give them approval rights. You can indicate that you'll give them consultation rights, which means that you'll talk to them along the way, but not that they can actually approve those type of things. The better way to address it is along the lines of what Romello is suggesting, is asking them if there is some very specific thing that they don't want in the movie. And that's what you could put in the contract, if it's acceptable to you creatively. I will not portray you using drugs. I will not portray you having been arrested. Again, if that works for you creatively, those type of things, those are objective. And at the end of the day, you can say you did it or you didn't do it, in the movie. But to give broad approval rights, it'll never be acceptable to a streaming service or to a studio or to most financiers. There's just too much risk there.
And even giving consultation rights, be sure that that's something you can actually follow through on, that you do have a plan to make sure that that person is looped in for important key decisions going forward throughout the production.
And a little bit beyond the scope of this discussion is the analysis of whether you even need someone's life story rights, right? Years ago, I represented the very famous nostalgic pinup artist, Betty Page. And represented her. I represented then a producer had acquired her life story rights, but at the same time, there was a movie being made about Betty Page. They absolutely had the right to make the other production without Betty Page's permission. You don't always need a contract with the person whose life story rights that you're going to make. Why do you get a life story agreement with an individual? Why do you pay for those rights? What you're paying for is most likely exclusivity, in the sense that that individual will only cooperate with your production and no other potential competing production. Another reason is for bragging rights, to say that it is the only authorized motion picture based on that particular individual. So it's for that. And then frequently, the other thing that you're paying for, again, if you're dealing with the individual directly, you're hopefully gaining some additional access and information that never was published in the newspaper or online or in some other source. So you're able to get some extra story value out of that person. And then also probably their commitment to help promote and publicize the movie when it comes out. So that's why you're doing a life story rights agreement. Again, Jeff and I could both do a story about Martin Luther King today. And even though there's been other movies already done about him, but whether we decide to, obtain rights from various family members or not, it's about access and about that exclusivity and that type of thing.
Yeah, and piggybacking on the access, one thing to make sure that is in your life story rights agreements is a clause that states you will have access to pictures and any sort of documents or anything about that person, and that there's an actual obligation from the person signing to provide you access to those.
Yeah, that's exactly what I did with the release agreements. I didn't have life story rights agreements or exclusivity with the 12 people who I interviewed for the 90s Club, but I did obtain release and permission from them to film them, of course. But then I also, like you were saying, obtained permission to use any of the photos or other archival information and things that they were sharing with me to use in the documentary.
To jump in on that, for interviewing, we've had it where the filmmaker will go, conduct interviews, and then after the fact, want to try to get releases. Maybe months later, they just didn't get the release, and it's, to further Bob's point, it's a lot better to do that up front before you start filming them, and to get that permission, rather than 6 months later you forgot to get a release from somebody, try to go back and do it. That just it's not as clean for sure.
So one thing that you can do on a more complicated chain of title, for example, if I were going to film, and we've worked on these type of movies. A number of years ago, I represented Benicio del Toro as a producer, and he was going to produce a movie based on the Hemingway novel "For Whom the Bells Toll." And this was written by Hemingway 70 years prior. One of the very first things that you do is order a copyright search report. So what that helps you do is to verify that you're actually dealing with the right people who have the authority to license the right to make a movie based on the work that you're saying. And this would be, certainly you would want to order that in terms of any type of, previously produced intellectual property, whether it's a stage play, you're basing something on a former television series, a foreign film, a novel, something like that. But you'd also want that if you're working off of a screenplay that had been with a couple of other producers in the past. and now it's your turn to give it a shot. This is something that you can obtain, and it'll show you the copyright history at the U.S. Copyright Office of the chain of title of the picture.
Yeah, super important. Your agreement with the rights holder should have reps and warranties from them, where they are repping that the work is theirs. They have the right to transfer the rights to you. The work is original, but getting a copyright report is also really important sometimes, because you would, it's a formal report showing things that, it's better to know that, just practically speaking, even if you have those reps and warranties and somebody forgot something, or someone else had the rights at a certain point, the formal copyright report could definitely shed light on some things that you didn't know.
And kind of a less way to look into things, but just as important, and something that people can sometimes forget, is when you're optioning something, really, you just need to dive in and really understand what you're getting. So just make sure you always do Google searches as well. So let's say you're trying to buy a book to make a movie. You need to find out, like, are there characters in that book that are also contained in other books that you may not be buying? If they are, then someone else could potentially buy that book and have the same characters from your movie appear in another movie. So you want to make sure that you really are buying everything that you think you are.
Yeah, I think the Google search is a great. Oh, sorry, Bob. Go ahead.
Yeah, no. Great place to start for sure. And I think, Jeff, what you were saying, which is, and again, I just trying to speak to this audience, I think it's one of the mistakes that we see a lot of, first and second time producers make, which is not clearly locking up the exclusivity on the rights that they're obtaining. They may feel that they're fortunate to be getting the rights, they're not paying for the rights, and they're just happy to get an agreement to have some, the right to make some production based on some underlying property. But absent that exclusivity, the producer is really going to have a challenging time trying to obtain the financing or distribution for that particular production, because nobody is going to finance, a multi-million-dollar production if at the same time the same story can be told, by a streaming service or by a competing motion picture. So, obtaining exclusivity on the property that you're obtaining is critical. I think we've talked a lot about the chain of title, and it's certainly an incredibly complicated area. I think we've touched upon a lot of the issues there. I think, but we'll shift now to maybe some clearance type issues. When the production is going forward, and Jeff, if you want, so just everybody knows, Jeff Watkins works on a lot of motion pictures, but is at the moment working on one of the, and it has been for the last year, been working on one of the largest television productions of all time, which is The Lord of the Rings, which was filming in New Zealand, season 1, and now just starting to film in season 2. So yeah, great job with that. That kind of a fictional made up world still has clearance type issues, but we tend to encounter clearance type issues much more when something is being filmed in the present day or the recent past. And that, do you talk a little bit about that, and certainly how you do a script clearance in advance type of thing?
Yeah, so you're going to want to read the script first off. But yeah, so you're really checking to see if there's any potential claim that anyone could bring. First thing I would look for, are there any real people involved? If there's a real person involved, are they saying things like he cheated on his wife a bunch of times? That would be defamation if it's not true. So you would really need to be clear of, can we say these things about these people, or could there be a potential claim brought? Other items would be, do they have plans for logos to be shown? Are they gonna show a big picture of the Coca-Cola brand and say something bad about it, or just feature it? you would have to get those cleared. And even things like I had one, so I have been in kind of Middle Earth for a little while, so there's not a lot there that is being cleared. But I did do, I've worked on a show where we just had a shot of a skyline, but it was taken out of context. It was being used in a different, it wasn't the actual skyline. It was taking some of the buildings and putting it into a fictional landscape, and some buildings are copyrighted. You know, you can copyright architecture. So we actually had to clear those. So anything that you think could be defamation about a person, anything that could be copyrightable, you need to make sure that it can be cleared, and if it's not, it'll need to be taken out of the script.
So, you know, different studios and different production companies have a varying degree of appetite for a little bit of risk or something. Yeah, there are quite a few places that will require you to clear, meaning to obtain permission from most any brand or actual product that appears, you know, in the production. That's not legally necessary. It's just desirable, probably from a financier or a distributor's perspective, because you know, because they don't want to have a potential claim. So, you know, the sense of, here I am drinking a Coca Light. It's a Coca Light because I'm in France, but it's a Diet Coke on camera. And as long as I'm drinking that and using the product in the manner that it's intended to be used, we typically really don't have a clearance issue in most instances. But let's say I'm in a Quentin Tarantino film and I'm taking this can of Coca Light and I'm using it instead to smash into the head of the character next to me. And I have brain matter splashing on my face and in my hair and that type of thing. Well, then you're going to obtain a legal claim from the Coca-Cola company saying that we've tarnished the brand. And you're going to have a substantial degree of risk in that type of instance of somebody claiming that you have misappropriated the use of their trademark or logo. And so that's where you may see a more generic soda can type of used in a motion picture or a television show when it's being used in that instance. Or, you know, if there's something violent or unsavory happening in a particular scene, you're not going to be able to obtain permission from a brand to be able to use their name in that scene. So that's a lot of times where you'll see, you know, some more generic product.
I was going to add to that, sometimes less focused on are things in the background of a scene. So if you have a particular piece of artwork in the background, also important to, you know, look into clearing that as well. It doesn't have to be, you know, the thing that's most prominent on screen. It could be things in the background that are copyrighted, like artwork or music playing during the scene. All of that should be cleared.
So I don't know, do any of you want to talk about locations at all? Locations are a big issue. And it seems like now, like compared to when I first started working at the beginning of my career, the production could usually turn over to a gas station, a university, you know, any kind of special, a restaurant, and say, here, please sign our production company location agreement, giving them permission to shoot at the location and film there. And now, years later, it seems that it's surprising to me how sometimes even the smallest of places, you know, it could be a diner in New Mexico that you think is off the beaten path, and they have their own version of a location agreement that, oh, we're not signing the productions. Here's our version of a location agreement. Anything to add there?
Yeah, one thing I would say that's important as just a best practice is what you don't want is you don't want to be stuck where you think you're going to load everything on the next day, but you still don't have that location agreement signed and you're stuck, and then you have to agree to all these things that you don't want to. What I would suggest for every single location, this may not be practical in all instances, but best practice would be find 3 locations that work for you. Maybe 1 is the best and 2 are kind of backups. And then a couple weeks ahead of time, get that the top choice that you have and see if you can lock it in. But if there's really some things like what if they don't want injunctive relief waiver in their agreement, which means that if there's a breach, they can stop you from showing your movie, which is a big deal, and you need to have that in there. You can jump to your backup with a week ahead of time, so you're not scrambling at the last second.
To add to that, Bob, like you were saying, where some locations have their own, ready to go location agreements to provide for you. Jeff and I were talking about this recently, where instead of trying to, you may not have the time or ability to negotiate every single location agreement you get that's already been prepared by the other party. It's good to have a one-page writer, a list of things or provisions that you need to have in that agreement. So that way you're at least comfortable about the things that are necessary to get, like, in terms of liability, no injunction relief, like Jeff just talked about. They can't stop your movie if they have a claim later. So you have like one page ready to go always. So if somebody says, this is our location agreement, this is what we have to use, we're not going to negotiate it, you can try to say, okay, well, can I add this, these are the things that are important to us, I don't want to touch your agreement, but I need these covered, and we'll attach it to your agreement and we can talk about it then. So they may not be open to negotiating the agreement, but maybe you can get a writer of a one page of things that you must get in there to have agreed to.
Yeah. So I was going to say, in addition to some obtaining permission from a particular location, one thing to be careful about is there may be local ordinances as well that relate to the filming. There is a movie that I'm not going to specifically identify a good number of years ago that I worked on where they were going to film and actually burn down a winery for a very key scene with a big actor. And they called me on the same day of filming and then said, we're going to burn down the winery today, but we don't have the local permit to do this. What do we do? And it's our only day to film it. So of course, I mean, you have to, as a lawyer, caution them in terms of there's most definitely legal risk here, but also be practical at the same time. And so just, my legal advice there was burn fast. But I think really the lesson there was more one about, and it's surprising how often production doesn't pay attention to those type of things, but it's kind of what both of you were saying, which is you have to think of alternatives and you have to prepare a meaningful period of time in advance to get those permits, to get the permissions, so that this all doesn't come down to, the morning of the shoot when these issues come up. And
on the back end too, you want to make sure you're not stuck where you can't get access back to the location. Every now and then you'll look on your shot and realize like, oh, we really didn't nail that scene, or there's a mistake there or something, and maybe we need to do a retake. What you want in your location agreement is the ability to re-enter the premises for the same price that you paid. It's an extra day or something, but a pre-negotiated rate for however long you think you may need to make a retake. Sometimes 18 months. It'll always be subject to their approval. Obviously, you're not going to enter in when they're running their business or something, but you want that ability to go back in and do a retake.
I think
great point.
Yeah. Really good point. I was going to mention that a lot of times people do talk about location agreements, but not location release agreements, which is when you are done with the location. When you're finally done with it, you have them sign a location release, which they're confirming that you restored the location properly, you didn't damage anything, and you left it as you came. That way, later on, something doesn't happen, and they come back to you saying, "Oh, you did this. I didn't call it out then, but I'm saying it now, and this is your, this is your damage that you caused." So to have the location or sign a location release, which says that you are being released from claims and you didn't damage the property.
Okay. Well, we're gonna move away from clearances for the moment, and just briefly touch upon the kind of the form of the production entity that people use. I think I alluded to this earlier, which is, most often when you're about ready to shoot a motion picture of any budget range, even a lower budget type movie, you don't want to do that in your personal name. And so what what happens is you typically form it's called a single purpose production entity. That means a company that is only going to be used to produce, the very one motion picture or television series that you're producing. And why do you form this corporation or LLC? Most often we see, for the past decade or so, most often it's an LLC that's being formed for independent production. And you do that to kind of shield yourself from personal liability, so that it is just, that motion picture that is, being run through that company, and that the company, rather than you as an individual, is at the forefront in the event that there's any somebody is injured during production, or there's a claim about a clearance issue, and these type of things that we've been talking about. Let's talk a little bit, Ramella, about the guilds, and just to kind of highlight what we mean by the guilds. That's WGA, SAG, DGA, and that means Writers Guild of America, Screen Actors Guild of America, and Directors Guild of America. And again, speaking to this independent film audience, many of the people, and certainly on a documentary, you're not likely to encounter those guilds or unions unless you have, if I had Morgan Freeman as a narrator of the 90s Club, had no narrator, but had I had Morgan Freeman as a narrator, I might have had to have dealt with one of those guilds because he is a union performer. But on a lot of independent film, it might be students who are student actors, people who are not guild members. But let's just talk to them a little bit about the guilds for a moment.
Sure. So you touched on a lot of the ones that we see: WGA, DGA, SAG, and IATSE. And these companies, if you want to make your production company a signatory company, that means you are signing, an agreement with each of these signatories, and you are intending to employ people that are guilds, that are union workers. And anytime you are employing somebody that is part of the union, there are a lot of considerations to take into account, a lot of rules that you must follow, of course, that protect these union workers. Things like fringes or residuals, or making sure you're not using their services over the maximum amount of hours permitted per day, set by the guild. So anytime you are employing somebody under these guilds, it's super important. Typically, when a production company, wants to employ somebody who is SAG, it's harder to then employ somebody who is not SAG. Like if you become a signatory company, you sign an agreement with the guild. It is harder to then employ non-union workers. Most of the time you have to employ then union workers and follow those rules. I think, Jeff, you had a case recently where they were trying to employ somebody who is not union, and there are really specific rules to follow when it comes to that.
Yeah, so there are some exceptions to the rule that you have to hire SAG. You can have a non-SAG person work on a SAG production through Taft-Hartleying them. And Taft-Hartley is an exception for very specific reasons. One of them being that they just don't have the amount of work in order to become a SAG member. And so then they can build up their credits to become one. Or maybe there's a very specific skill that you need from an actor, like someone who's really good with juggling something that you can't find a SAG member that does this one thing that's in the script. You can Taft-Hartley non-union people in through that. But typically, you're going to need to hire SAG members to work on your SAG production. One thing to remember, though, is there are instances where SAG people can work on non-SAG productions. Oh, hold on, my light turned off. So there's a thing called financial core that allows SAG members to work on non-SAG productions. So let's say you've got a production and everyone's non-union, but you have this one person that you know is probably SAG. Do you have to switch the entire production over? Not necessarily. That person could be a financial core member, and maybe he can work on a non-SAG show. And so you can still run your production as non-union in that instance.
So yeah, with that's come up for us before too, is in oftentimes with production shooting overseas, and whether there's actually an entirely foreign production, whether it's French or Spanish, and they would like a US celebrity who's very well known to appear in the production. And SAG is the one union that does have this kind of what's called like extraterritorial jurisdiction, that they require their members to work for SAG signatory companies, even outside of the United States. So it can be an entirely French production with all French actors shooting in France, financed by French money. But if we ask Alec Baldwin to play a role in that movie, he's going to need to work under the Screen Actors Guild agreement. Again, there's a couple of exceptions, which is if the rest of the cast and crew is working pursuant to some other guild agreement under the UK or Australia or Canada, but there's not really an exception for France. But that there's ways to do it where a single actor or a few actors can be engaged on a production SAG without converting the rest of the production to being a SAG production. And there's a proration of residuals and that type of thing. But what are some of the consequences, Jeff and Rommella, of, let's say we're prepared to hire a DGA director or a Screen Actors Guild member. Why are we concerned about that? What protections or benefits do they have?
There's a couple big ones. One of them is they get a minimum fee for all of their work. So if you're a SAG member, you're going to have a minimum daily rate, which is fairly high for an independent production. You may not want to pay that. But on top of that, you're also going to have rules around their workday. So if the production needs to work, just a ton of hours during a day, there are going to be limitations on that, and there will be overtime pay if you have to work on the weekends. There will be mandated overtime pay for those weekend days. Then on top of that, you're going to be paying fringes as well. So payments into their healthcare accounts, for instance. So that will be all on top of their fee.
I was going to add, there's also non-financial benefits, like for directors under the DGA, they get the right to a director's cut. So that's a creative benefit that they get and they're protected from due to the DGA. They might be getting that anyway, but the DGA, tells them that they have to be getting that, which is a creative benefit guaranteed for them.
So one of the other areas I think that we should touch upon, and Jeff, I'm going to ask you if you would do it, which is the engagement of a minor on a motion picture. So what that means is not somebody that's digging coal in West Virginia, but a minor is somebody under the age of 18 years old, most typically 18 years old. It can vary state by state in terms of who is considered to be a minor. But what are some of the kind of special consequences of working with an actor who is 18 years or under the age of 18 years?
Yeah, so the big thing for minors is that if they enter into a contract they can, I believe it's void the contract at any time, so that they could essentially get out of the contract because they're minors. The reason why that's bad is that you could shoot a couple scenes with them and they could decide, I don't really like how this is going. I don't want to be a part of this movie anymore. I'm going to avoid this agreement. And now you've just wasted days of shots and you've got people working and you can't use anything and you have to recast. The way around that is you can submit the contract and get the court to approve it. In LA, there's like one court that you can go to, and there's a whole specialized system, and there's a woman that kind of runs this program that is very good at running this and getting things through. And the court will look at it and say, okay, yeah, we agree this is fair pay for what he's getting. All the terms look good. We're going to affirm this contract so that can't happen, and you can rely on the contract. On top of that, there's a thing called a Coogan account. And I believe, Romello, you've worked on this recently, right?
Yeah, in certain locations like California, New York, I believe New Mexico as well, there are child actor labor laws which say that the employer making the payments to the child also has to set aside a certain amount of their paycheck, 15%, into a bank account. It came from the child actor, Jackie Coogan. Now it's called the Coogan Law or the Coogan account. And that basically it mandates that as the employer, you have to set aside 15% of the child's gross earnings into a trust account for the child to be able to access when they're 18. That way, no matter what, the child is working, they're not in charge of their finances, but they will have that backup 15% from their earnings and be able to, recoup that when they're at legal age.
Yeah, just to clarify, I think like the court will look at it on a case-by-case basis, and they might even decide that, again, it could be 15% for somebody who's not making a particular large, salary, but if it is, a well-known child actor who's making even a couple of $1 million, the court may require that 50% or more of their compensation, 50 instead of 15%, or more of their compensation should be set aside in this protective account for them, because the parents or guardians don't need to be retaining millions of dollars in order to kind of manage, to drive them to and from the set and that type of thing. And again, when working with children, because they don't have that authority to sign on their own behalf, people will often get a parent or a guardian to sign. It is very, very important that you get both parents to, and whether the parents are together or they're separated or divorced, all the more reason to get both parents to sign, because you don't want a mother to have signed the permission and then the father to say, well, I don't give authority for my daughter to appear in the movie and I have joint custody over her. So it's very critical to make sure that you have both parents at a bare minimum signing and giving that permission. I mean, should we talk a little bit about? It's definitely not a sexy area in any respect, but insurance. A little bit about what type of insurance people get in connection with productions.
Yeah, the main two types you're looking for are kind of a general liability insurance to cover kind of any sort of damage issues that are coming up. One big one is errors and omissions insurance, which is going to cover all those clearance issues that we were talking about, or if there's an issue with chain of title. I remember, Bob, I think you were talking to me the other day about how this is something that a lot of producers tend to push off to the end. But it is incredibly important that this insurance comes in case you get a claim later, to make sure that those claims can be covered, because there's a million ways that there's so many pieces to a movie, and there's so many people involved that if something slips through the cracks, you want to make sure you're covered for a potential claim that could.
Yeah, again, on a lot of independent productions, the producers, particularly at the kind of the film festival level, have not obtained yet their errors and omissions insurance. And at a bare minimum, every producer should at least have a quote for how much that insurance is going to cost, because no distributor or recognizable television network or streaming service will take your motion picture, documentary or scripted, without you providing errors and omissions, or what's called E&O insurance. And at a minimum, they'll require usually 3 years of protection of insurance, and then they will have a liability range for that and a deductible range for that insurance. It's going to vary, but it could be a minimum of 1 million or 3 million, and a kind of a ceiling of $3 or $5 million per claim, and then a $25,000 deductible is maybe kind of average or something like that. But you should get a quote, because you will have to purchase this in order to conclude your deal with any distributor. So that needs to be taken into account. If somebody's going to pay you $25,000 to distribute your movie, $250,000 or $2.5 million, your insurance isn't going to change the cost, but you'll be having to bear this. And the range for that insurance could be, $15,000 to $25,000 or so, to obtain that type of insurance. So make sure that you're taking that into account when you're doing your deal.
I was going to add, also make sure you're taking into account how long it might take to cover your specific project and how long it might take to actually get the coverage in place. So you want to also provide for some cushion to make sure you are covered when you need to be.
Yeah, so I know we probably just have a little, about 20 minutes left, in terms of talking. I think there's 2 other areas I think we should probably touch upon. The one is not necessarily production related, although there is no production without financing and the money to make the movie. And just as critical as all these other agreements, the financing arrangements do need to be clear upfront and in place, going forward. Great to get somebody's money in hand, but you won't be able to distribute that picture unless you're able to tell your distributor what your financing arrangements, or be in a position to share what your financing arrangements are. On independent productions that are financed, through third parties and equity sources, friends, family, and that type of thing, there is a general rule of hand on those financing arrangements. Again, we've definitely seen it vary and be different depending on the risk level of the motion picture. But the typical rule is that the financiers who put up the money for the movie share in 50% of the revenue from the movie, and the other 50% of the revenue go to the producer and the talent of the movie. Producers are going to want, or financiers are going to want to be repaid first, and they typically are going to require a premium on the money that they put up. That premium ranges most commonly from 10% to 20% on the high end, and typically we'll see 15%. It's kind of an average premium. So if your movie costs $1 million and you're raising that from wealthy individuals and friends and family and the collection of financiers, you know, they're going to expect to be repaid their financing contribution plus 15%. And all the financiers are going to want to be repaid typically before anybody else in the cast and crew and the producer and the director start getting some other sort of back-end participation. So again, using this example of a $1 million motion picture, and somebody puts up, let's say they write a big check, 500,000 of the 1 million. So they've put up half the budget of the movie. When the movie breaks even and all the financiers have been paid back and they get their premium, this financier will then, they don't get 50% of the back end or the revenues from the movie because they put up 50%. They typically receive 50% of 50% that's allocated to the financiers, or in other words, 25% of the back end. And the other financiers get the other 25%. And that 50%, the other 50%, is again allocated to the producer, the director, the actors, and other talent in connection with the movie. So, well, I think that's all we'll kind of say for the moment on the financing side of things. I think we'll shift a little bit and talk about some of the kind of the key talent in independent and studio movies, which is directors and actors. So Jeff and Romello, if you want to touch a little bit upon those type of deals.
Yeah, so for actor deals, it's fairly straightforward. It's not quite as complicated as the rights deals that we were talking about before. Key point is obviously going to be money, whether or not that's, there's three types. There's a kind of a Schedule F, which is they're going to be getting just a set compensation for their entire work on the film because they're a bigger actor, so they're playing like more of a lead role, so they're getting just a chunk of money for the entire work. You could also have a weekly actor where they're being paid on a weekly amount, and you get them for a set amount of time, and once they're done, they're out. Or you could have a day player that's showing up to do one scene, something like that. Key pieces that you're going to care about for an actor deal would be, so you've got the compensation, the exclusivity is going to be big. For a larger star or your lead, you want to think about, do you care if this person is showing up in other movies and there's going to be multiple movies with this person at once? Are you concerned at all about oversaturation of that person, or do you want to be the movie with that person in it, maybe for that summer? And then another big area is going to be scheduling. I find that's one of the more negotiated pieces. Actors kind of by trade are always bouncing around from gig to gig, and you're going to really want to be able to lock down when they're going to be available, and how long they're going to be available for the movie, and make sure that they're not going to have to. There's not an end date where they have to jump off to another movie in case you need to do some reshoots, or maybe things in productions go wrong all the time, and maybe you need a couple extra weeks. So try to build a buffer on the back end to make sure that that actor is available to do the work.
I think that's such a great point. We had for a production we're on, we had a deal recently where the specific dates they needed the actor wasn't fleshed out early. Like, they punted it till the long form, and the long form was taking a while to wrap up. And it turns out that the actor, not even on an extended date, but just during the regular shooting schedule, was also booked on another film, like halfway across the world, right? So you don't want to be in that situation where now physically your actor is not going to be there, and then we had to negotiate with that other film company and try to figure something out and get a compromise on the dates. So I think that's a great point, just making sure you have the actor for when you need, and building in that cushion, like Jeff said, in case you do need some reshoots later on.
And one thing to ask them too when you're scheduling this is, do you have other projects that are in first priority? And what that means is, even if we lock down an agreement, is there something else? Are they making something for Netflix, or there's another studio? Are there obligations there in first priority? Meaning, if that job calls for them, they have to go. So if that job says, actually, we're shooting a week early, they literally have to leave your set and go work for that job.
Yeah, so that's one of the pitfalls that we see on a lot of these independent productions. I think there's a couple of others. Again, low budget, independent productions. The producers, directors feel so fortunate to be able to land a star or recognizable talent in their movie that they will compromise quite a bit and almost give too much that ultimately won't be acceptable. So some examples: approvals, just like we talked about in the life story area. There's certain permitted approvals for a big actor in terms of how their name or likeness is going to be used going forward. But you know what? You're going to be able to need to use them in the trailer. You're going to have to be able to put them on the poster and all of these marketing type of things. And you cannot give an actor, no matter how big they are, the right to have kind of an absolute approval over those type of marketing decisions, should you be so fortunate that a major streamer or a major motion picture company wants to distribute your movie. They're going to want to make those decisions. They're not going to want Nicole Kidman, Tom Hanks, whoever, even no matter how big they are, making those decisions for the studio. Again, there's certain consultations or certain approvals that they might be able to have, provided that they definitely agree to be in a certain reasonable number of these type of things. The other thing that we see a lot of independent productions do, which is giveaway bonuses. These are box office bonuses, award bonuses. If somebody receives a Golden Globe, somebody receives an Oscar, this type of thing. Years ago, these type of bonuses were all quite reasonable to give to talent. But there is a risk, if you're an independent producer, in giving these things without distribution in place, because you as a producer might get stuck bearing these bonuses and having to write those checks. So let's say I am, fortunate enough as an independent producer on my small movie to get Jennifer Lawrence to come in, do, a 1-week shoot. And you know what? I'm paying her nothing. And she wants some box office bonuses if the movie is successful. Fair point, fair request. But as an independent producer, be wary in the sense that, let's say I promise her these bonuses, who's going to pay them? I've worked on movies that have been the subject of bidding wars at Sundance. And even one year, one of the films that sold for the highest dollar figure at Sundance, and the distributor picked up, the buyer picked up the box office bonus for the main star in the movie, but not the other 2 stars. And what that means is, that if we hit those box office levels, they were going to pay, the distributor would pay the big star, but the producer had to pay the others. And, at the moment in time, because the box office, again, is very early in the life cycle of a movie, right? First week, second week, third week of release of the movie. And apart from maybe the payment that you got from the distributor up front, the producer hasn't received any other money from the movie. And now you might be stuck having to write a check. The other thing another very frequent mistake that we see made by producers who feel very fortunate to have big name talent attached to their projects is the giving away of credits. And committing that the actor will be in the poster, committing that everybody's name will be on the poster. And you have to be very wary of marketing decisions. These type of things might all seem reasonable up front, but again, when a studio buys your movie, they might imagine a completely different sales pitch for the movie, where they don't want to sell it based on stars. They want to sell it based on concept, or they want to show the entire cast and not just one cast member. So you have to be very careful in promising kind of marketing type of decisions to your cast along the way.
Yeah, I think that's super important. We've unfortunately seen like the studio's marketing plans hindered by one actor's approval rights that they were given even a month ago, and it could just derail the plans that you had for marketing of your own film.
Yeah, and I think we're kind of winding down here.
It froze for me.
Me too.
Yeah.
Okay.
Robert, can you hear us?
Frozen.
Maybe he'll try to get back on.
Yeah.
The others want to jump in for a minute while he's.
Yeah. So I agree. It seems like we're kind of winding down. But one other piece I wanted to talk about was just the general production packet that you're gonna want. So this is a big piece for us lawyers when we're working on a film. Is we create this like packet that's got 15 agreements in it. And what that is it's basically to make sure that you have in place a whole bunch of forms when you're going out, and you can have location manager have a form, you can have your UPM have a form. So just make sure that before you start principal photography, so this is maybe a couple months before during pre-production, make sure you get all your forms together. And everyone kind of has a different take on what's included in a production packet. But some of the key ones are like, you're going to want all your crew agreements. You want like a set crew agreement for every single person, because a lot of the times they're going to have the hours that they work, and you want everyone on the same hours.
You're gonna add, Jeff, like rental agreements too. Like sometimes people don't or forget to consider, catering for your cast and crew. Where are you gonna have that? Do you need to rent out a small space for that, for lunches every day? Or even just parking. Do you guys need, to arrange for parking, and you need to set up agreements in place for that? You don't want to show up the day up with all the equipment and have nowhere to park it for, for that day. So yeah, that package is super valuable, super important, and just gives you help with a packet of forms that you can go through and really set yourself up, for the first day to just kind of hit the ground running.
Yeah. So other key things that you're going to want in there are the equipment rental agreements. Right. A lot of times I see like car agreements, so that you have the ability to film people's cars. Like basically just like a simple release. You want a materials release. So anytime this goes back to the script clearance part that we were talking about, is anytime you have anything you want to clear, you want a form so that you're clearing everything in a similar way, to make sure that you have like the exact same rights for all these different pieces, to help you with the ability to distribute later. Let's see.
So
I was gonna, go ahead, Bob.
Yeah, I'm back.
Yeah.
The Wi-Fi went out or something. But the point I was trying to make was that it's important to budget, or at least have an understanding of how much it's going to cost to deliver your completed movie, right? You've made your movie, you're ready to submit it to film festivals, but that's a lot different than what it's going to cost, or what you might need to deliver in terms of film elements to an end user distributor, right? And you know, online, or that you should be able to obtain and take a look at different kind of delivery schedules from various distributors and networks and that. But these additional film elements could cost you from $25,000 to $75,000 of additional money, and just be prepared that you might have to advance these in order to deliver it to a distributor, in order to get that license fee that they're going to pay you for the movie.
And like you said, each studio might have different requirements, likely do. So just to make sure you're getting what you need for that particular distributor.
Yeah, and I think again, even on I don't know, we didn't really talk too much about music, right? But just to wrap up here on a musical end note, if you're having original music composed for your film, that's fairly easy in the sense that you will engage your composer on a work for hire, meaning you as the producer will own that music basis, and everything that they create will be owned by the production. The trickier thing is when you're licensing music from other sources. There's really not free music available. Just because you've taken it from the internet doesn't mean that it's available to you for free. Even on a small movie, like mine, where I've licensed a couple of tracks, see the complications related to licensing, music. You need a license for the master, which is the sound recording, and also for the underlying composition on the track, if it's a known track.
Yeah, and then one just funny. There's one way that people try to is so there's two types of licenses you have to get: the license for the composition and the license for the recording. So one way to save money is to do a cover version of the song. So you're only paying for the license for the composition, but then you make a new recording, so you don't have to license that anymore. If you do that, make sure though that you're not getting too close to the original version. I think the case I'm thinking of that I learned about in law school, I think it was a Tom Waits track that someone tried to pretty much exactly kind of like copy Tom Waits' voice. I think it was very distinct.
Yeah, that was a Frito-Lay's case.
Wasn't that the chip?
Oh, you know it. Yeah.
Yeah, and there was a similar one with Bette Midler too, which is so they didn't license the underlying Bette Midler track, but they recorded their own version, and they told the singer, sound like Bette Midler when you sing the song.
You don't want to be too exact.
Imitated.
Yeah. Well, and as I've encountered, again, on the 90s Club, I cleared the compositions and the musical tracks for my film. At the opening is a song that was performed by Jimmy Durante. It's an old classic. And then in the closing tracks was Dick Van Dyke singing a song by a very famous composer, Hoagy Carmichael. I got what is called like a festival license, right? Which is a license for 1 year. Now my music has not been cleared till the end of time, which ultimately anybody who's distributing their picture is going to need to do. So you might be able to get these more limited licenses at a lower dollar rate, but it's important to understand if the music can't be extracted back out of the movie, then they would essentially have a gun to your head, right? In saying, we want $1 million for you to use it in the future. So either have a
Rose for me.
Lose them again.
Yeah. Okay.
Bummer. But yeah, his point though being either have a license that says you can use it for any purpose, forever, everywhere, or make sure you can swap in and out songs. So if maybe Germany you don't have the ability to use to exhibit, make sure you can just sort of take it out and swap in another song, and no one can even notice. So you don't want references to, oh, cool, but I hear Bette Midler singing in your script if you think you might do it.
I think it's going to try to get back on, but should we turn to any questions maybe?
Daniel says he has questions.
Oh, cool.
Please feel free.
Can you hear me?
Yes.
Yeah.
Yes.
So sorry, I came in a little bit late because I got messed up with the time zones. So I've been here only like 15 minutes.
Okay.
But so I've worked in different productions for different films and documentaries, and I write, and I started out, I would write just as a hobby, and now I'm trying to become a writer for real. And I had a script that was picked up for production. Originally, they were planning to produce on March of this year. Because of budget, it got pushed to November. Because of budget again, it's now pushed to March. So like what I'm concerned about is that it's going to be pushed indefinitely. And on the contract that I signed for this script, there is no time constriction of any kind.
Yeah.
So at any point in time, if they come up and say, well, we're going to have to push it again, and it just keeps getting pushed and pushed, at what point can I say, well, you're just not going to do it? So, or am I stuck with that contract?
Without knowing much more, it does sound like you may be kind of stuck. With the way the contract was written, I'm guessing it was they acquired all rights to it and they bought it outright, or did they option it?
No, there's no option on it. It's bought. It's bought for 10% of the budget, and 10% of the budget, and they offer me 10% on the back end.
Yeah, so it does sound like you're probably kind of locked in there. Sometimes there's a few ways that you would kind of do it at the outset. So if it's an actual, one way would be, maybe they just option it, and then if they decide they don't want it and they don't want to pay for it, then they would just give it back to you. Sounds like that didn't happen. The other way to kind of protect yourself is the same thing, version right, but that you do have to have it in the agreement. And what those provisions say is if you start principal photography by X date, then it automatically goes back to you, or it gives you the right to have it back to you. If there was any payments made to you, you would have to pay it back usually. But for that to happen, that would have to be it.
Understood. Yeah, it's the first time that any of my writings gets picked up, so I was just really excited. But now, now I'm thinking, man, like I should have thought of this before.
Is there any problem for sure?
Yeah.
It's a common problem. It's unfortunate, but yeah, the more you can protect yourself up front, of course. But that, no judgment. It's a very common problem.
Yeah.
Is there?
Like maybe you go talk to them and say like, hey, like I see you guys aren't. Unfortunately, there's no contractual way for you to do it. There's no legal basis. I don't, from what it sounds like at least. But you have a conversation with them. Be like, look, I just really care about this. Unfortunately, they've probably sunk some costs into it if they keep trying to start it up. So you would have to be prepared to maybe some of that if you're asking back to you.
Yeah. Okay. All right. Thank you. Is there benefits to joining the Writers Guild? Because I've heard people say no. I've heard people say yes. Like, what are you guys' stance on that?
There's certainly, I mean, the downside would be if you join it, you know, maybe that would limit you more to working just for WA projects. But again, you could be like a financial core member. I mean, there's tons of benefits though. You know, there's protections for you working for a minimum amount. There's all sorts of rights protections. So like, for instance, there's a thing called separated rights. So if you write a script and it's subject to separated rights, they don't pay you enough, you get to keep, there's this like whole chunk of rights that you get to keep. You would get fringe benefits for health and pension. Yeah, there's a bunch of protections for sure.
Yeah, I think it's a personal decision, but you know, objectively, it does have its protections.
So would you say it's worth it?
I mean, I think it's a personal decision. I think it would just be weighing the pros and cons and kind of seeing what fits for your situation.
Yeah, but you can look at the WGA minimum basic agreement. If you go, if you can just Google it, and you can look through the agreement and see all the different protections on there. And then it kind of depends on like, especially like what your circle is like. You know, are you going to be able to find WGA work if you join, or do you want to kind of get started more doing like non-union productions? Then maybe hold off on it for a little bit.
Okay, yeah, that actually helps me a lot. Thank you.
Especially something like the WGA, there's a lot written about it. Obviously the basic agreement itself, but also just general articles. There's a lot written about it. It's definitely one of the, of course, more popular unions.
Thank you for your input.
Yeah, sure. Well, any other questions before we head off? Sounds good. Well, thanks, guys, for having us. This was super fun to be able to do. Hope it was helpful to kind of get this like very broad view of all the production legal.
Thank you so much. And Daniel, thank you for joining live.